So when you get close to the date of the trial itself, there are various things that you should be thinking about in order to make sure that you're well prepared for the trial, for the hearing itself. One thing to bear in mind is that the tribunal hearing is likely to be held in public. That is, the room in which the tribunal hearing takes place is open to the public, and it may be that during your trial, during your hearing, there may be members of the press or of the public who wish to come in and sit at the back and observe part of the proceedings. And that's not unusual at all, and so shouldn't be something that should faze you. But it's also worth thinking about, because it does mean that in advance of your own hearing, if you wished to, you could go along to the employment tribunal and sit in on someone else's hearing just to observe and get a sense for how it works in practice, which is quite a useful preparatory step and some people quite like to do. The hearing itself will be almost certainly be at your local tribunal, because the proceedings will normally take place at the tribunal which is closest to the place of work of the claimant. So it normally shouldn't be too far to travel. And when you get to the day of your own hearing, you'll be expected to get there well in advance of 10 o'clock, which is the date on which the time at which the proceedings normally start. So it's worth getting there probably at least half an hour or 40 minutes in advance, just to make sure you're settled in and have got a sense for where you need to be. Before you arrive at the tribunal, you should make sure that you have copies of the bundles that I mentioned earlier, so the bundles of disclosure, the bundles of documents that you'll be referring to, and also copies of the witness statements of the witnesses that you are bringing to the tribunal. That's because when you get there, you'll be shown through to somewhere known as the respondent's waiting room, and when you're there, you'll be approached by a clerk of the tribunal who will ask you to provide them with copies of the bundles and with copies of your witness statements, which they will then take through to the tribunal judge, who will probably have a look through some of the key documents and do a little bit of reading in perhaps before the hearing actually kicks off. If they don't have much pre-reading to do, or if they just want to get started straight away, then they will normally ask you straight through to the hearing room at around 10 o'clock. The room itself is not your stereotypical courtroom. It's a relatively informal setting, so it just feels like a large meeting room in any normal building. The employment judge, who you would normally refer to as sir or madam throughout, will be sat at the front facing you, and to either side of him or her will normally be two people known as the wing members. That's because traditionally the employment tribunal is set up so that there is a sense of fair representation for the general views of both employees, individuals, and employers. So in addition to the tribunal judge, who will be legally qualified, there will be the two wing members who are ostensibly members of the public, one of whom will perhaps have a large amount of trade union experience, and the other of whom maybe has a large amount of industry experience as an employer or a senior individual within an employing organisation, to add a sense of fairness and balance to the proceedings. As I said, you'd refer to the tribunal judge as sir and madam throughout. They will normally refer to you as the claimant, or by name quite often. It is a fairly informal process. And when the hearing starts, when they've read through the papers, they will probably explain a little bit about how the process and how the day is going to run. If your hearing is just one day, then they'll probably set out a fairly tight timetable. If it's a longer hearing of several days, it may be that they'll be a bit more flexible about exactly what happens when. But you can be fairly confident that the employment tribunal judge will take control from the start, both of the timetable and of what you need to do and what you need to have prepared for when. Once they have gone through those introductory remarks and comments, the first thing would normally be for the claimant, who will normally be sat on the right as you go in, for the claimant to get started by putting forward their first witness, who in most cases will be the claimant themselves. And the claimant, as the witness, will then move forward and stand at a separate table, which will be at 90 degrees to where you are and where the judge is, and will sometimes start by being asked to read their witness statement, or sometimes will simply be asked questions by the Employment Tribunal judge about their witness statement. But you will also be given the opportunity as the respondent to cross-examine the claimant. So that means you will be given an opportunity to ask questions of the claimant about their own witness evidence. So you should be sure that you've familiarised yourself with the content of their witness statement well in advance, so that if there are areas where you think they may not be giving the full picture, or where you think that you would like the tribunal to know a little bit more, you'll have the chance to cross-examine them, to ask them questions about those areas of their evidence. Once the claimant and their witnesses have finished giving their evidence, you will then be asked to put forward the witnesses for the respondent. It may be there are very few of them, or it may be there are a number of people who you have asked along and for whom you have provided witness statements, and they will then take it in turn to go through the same process of sitting at the witness stand and receiving questions both from the Employment Tribunal judge and from the claimant or the claimant's representative, if they have a representative there. And that can be a process that is quite daunting, giving evidence and being questioned on your version of events, but you will be led through that process quite well by the judge, who will prevent the claimant from asking questions which are irrelevant or unnecessarily aggressive.